All right, welcome to this explainer. Today, we're diving into the absolute high-stakes world of Pakistan's special criminal laws. We're going to decode exactly how bail works when the standard everyday rules are completely thrown out the window. If you're a law student, a practicing lawyer, or aiming for the judiciary, understanding how courts balance individual liberty against national security and public safety is absolutely crucial.
So, think about this for a second. Can a person accused of terrorism actually get bail? I mean, it sounds kind of impossible at first glance, right? The stakes are unbelievably high, and these laws are designed to be entirely unforgiving. But, as you'll see, the legal reality is fascinatingly complex.
And what about massive drug trafficking busts? Is bail even a possibility when we're talking about huge commercial drug recoveries? Or think about high-level white-collar criminals facing the sheer, overwhelming investigative power of accountability laws. How do courts actually decide who walks free pending trial and who stays locked up?
Here is how we're breaking it all down today. First, we'll look at the liberty exception. Second, Anti-Terrorism Act restrictions. Third, narcotics and Section 51. Fourth, NAB and accountability laws. Fifth, we'll compare these different regimes side by side. And finally, number 6, the crucial judicial bail principles you need to know.
Okay, let's jump straight into Part 1, the liberty exception. So in ordinary criminal procedure, your liberty is heavily protected. The absolute baseline is the presumption of innocence. Bail is generally the rule, and police remand, that's capped at a strict 15 days. But when we step into special statutes, the legislature completely flips the script. Because of the extreme severity of these crimes, we're talking terrorism or massive corruption, strict statutory bars are suddenly slapped onto bail. Liberty literally becomes the exception, and those pre-charge detentions are heavily extended.
But here's the thing. Even with those aggressive rules, we still have a constitutional anchor. Take the landmark 2010 Supreme Court ruling in Tariq Basser versus the state. This case anchors our baseline under Article 9, which guarantees the security of a person. The court made it clear that pretrial detention is a massive deprivation of liberty. It has to be heavily justified by the state. The burden is entirely on the prosecution to prove exactly why you should be locked up before a conviction, not the other way around.
Moving on to Part 2, Anti-Terrorism Act restrictions.
Under Section 21D of the Anti-Terrorism Act, or the ATA, a suspect can face a pretty terrifying 30 days of police custody. That is double the normal 15-day limit of ordinary criminal law. The authorities get a full, uninterrupted month to investigate before the accused even gets a real shot at fighting for bail. Plus, the Anti-Terrorism Court has exclusive jurisdiction here, and bail simply cannot be granted without giving the prosecution advance notice.
So, does this mean getting bail is just impossible? Actually, no. In the 2019 case of Shahbaz Hussain, the Supreme Court clarified that while the ATA definitely imposes higher standards, bail can still be achieved. The Anti-Terrorism Court can't just throw out generic fears of terrorism to deny bail. They must pinpoint specific, articulable reasons why this exact specific accused poses a risk of committing further acts of terrorism if they're let out.
All right, Part 3, narcotics and Section 51.
When it comes to the Control of Narcotic Substances Act, specifically Section 51, the law just drops a hammer. It clearly states that no bail shall be granted if there are reasonable grounds to believe the accused is guilty of an offense punishable by 14 years or more. Because trafficking commercial quantities of narcotics carries life imprisonment or even the death penalty, this statutory bar immediately blocks your standard, everyday bail applications.
So how exactly does a defense lawyer fight what looks like an absolute brick wall? Well, if you look at major Supreme Court cases like Gul Mohammed, the whole strategy is to aggressively attack the phrase reasonable grounds. Defense lawyers can bypass that Section 51 restriction by methodically tearing apart the police's recovery evidence step by step. Was the drug recovery witnessed only by cops with absolutely no independent civilians around? Was there some unexplained delay in sending the drugs off to the chemical examiner? Are there broken links in the chain of custody? If you can expose these flaws, you prove there are no reasonable grounds to believe guilt. And just like that, the door to bail swings open.
Let's hit Part 4, NAB and accountability laws. Get this, 90 days. Under Section 24F of the National Accountability Ordinance, authorities can detain a suspect for up to 90 days without even filing a charge sheet. That is literally the absolute longest pre-charge detention permitted anywhere in Pakistani law. But again, the Constitution fights back here too. Just look at the monumental 2018 Khwaja Muhammad Asif Supreme Court case.
The court really pushed back against these incredibly strict rules, ruling that the right to bail, which is fundamentally tied to the constitutional right to liberty, simply cannot be erased by legislation. Yes, the NAB imposes a super high evidentiary threshold, but it absolutely does not allow for indefinite detention. The court made it crystal clear that prolonged pretrial detention without a trial heavily favors granting bail, and accountability courts really need to actively manage that balance.
Part 5. Comparing the bail regimes.
When we stack these regimes up side by side, the contrast is wild. We're talking a massive jump from a 15-day maximum remand in ordinary cases to 30 days for terrorism, all the way to 90 days for NAB. And the jurisdictions shift completely, too. Ordinary courts are bypassed entirely in favor of specialized anti-terrorism courts and accountability courts. The burden of proof shifts, the statutory prohibitions get tighter, and the defense really has to elevate their arguments to keep up.
And finally, Part 6, Crucial Judicial Bail Principles. Across all these daunting special laws, the ultimate key to unlocking bail almost always comes down to defeating reasonable grounds. Whether you're facing the death penalty under ordinary law or dealing with the strict statutory bars under the CNSA or NAB, you have to remember the court is not running a mini-trial at this stage. They're just making a tentative prima facie assessment. They're looking right at the surface of the articulable evidence. Defeating this threshold by exposing weak prosecution evidence like biased witnesses or completely uncorroborated allegations is exactly how you secure bail.
Courts are basically juggling a few major factors here. First up is the classic three-prong test, looking at the evidence, the gravity of the offense, and the risk of flight or witness tampering. Second, we have the incredibly important exceptions under Section 497(2) of the CRPC. Even in capital cases, women, minors under 16, and those who are sick or infirm can be granted bail. Case law like Shamim Bibi completely backs this up for female accused. Third is the delay in trial. As the Supreme Court pointed out in the Azhar Iqbal case, holding someone for a prolonged period without a conviction is basically premature punishment, which strongly favors giving them bail. And lastly, if the police's case clearly requires further inquiry just to prove guilt, bail should absolutely be granted.
So, this leaves us with a pretty profound question to chew on. In a system that is explicitly designed to protect society from its most dangerous offenders, we're talking terrorists, cartels, corrupt officials, how do we ensure the exception doesn't permanently erase the constitutional rule of liberty? That right there is the fragile, complex balance every judge and lawyer has to navigate every single day. I really hope this explainer has given you the foundational tools to analyze these intense legal battles brilliantly yourself. Thank you so much for hanging out with me to learn about this and keep questioning the law.